Hello, my name is Marc Markel, and I'm here as a representative of the Community Association Institute of San Antonio. I'm also an attorney with the law firm of Roberts, Markel, Weinberg, Butler, and Halley, and we have offices around the state, including one here in San Antonio. And our practice customizes around and representing community associations and the issues that surround them. I've been asked today to talk to you a little bit about what a community association is, what it isn't, the purpose of them, and then additionally to talk to you about some recent legislation which affects community associations and realtors. First off, community associations operate in different housing environments. As you know, there's single-family communities, there's townhomes, condominiums, and mixed-use master plan communities. And community associations are not mandatory for these types of housing environments except in condominiums, where the state has required that all condominium associations be incorporated as associations. Now, community associations exist for many purposes, the most important being to protect and preserve property values, and also to do this by providing maintenance to common areas which are used by the residents, and by enforcing restrictive covenants which will help to maintain the appearance of the community. While some folks think that community associations exist just to harass residents, it truly exists to maintain and enhance the property values of the community. It's easy to see in a community where active association exists versus one that doesn't by just driving through the communities and seeing how the yards are maintained in many of the communities. All the forms of community associations, however, are referred to by the Texas legislature as property owner associations, or POAs. Now, when a POA exists, or a community association, it is a mandatory membership organization, and the obligations of the owner and the association run with the land. That meaning that you can't sever yourself from it. This is compared to a civic club, which is a voluntary civic organization, and often in a community would allow somebody to merely have a situation where they could put themselves in a position where they didn't have to be a member. Those would be like where they would have dues versus association assessments. Assessment liens would be an issue. Both of these organizations have board of directors. They're usually elected by the membership, and they usually serve as a volunteer on those boards without compensation. The laws that I'm here to talk to you about today are laws which came primarily out of the 82nd legislative session, which was our last legislative session, and many of these bills went into effect either September 1st or earlier or later, and all of them will be September 1st unless I point those out to you along the way. One of the things that was added by the Texas legislature was a definition of development period. Now, some of these exist inside of deed restrictions or restrictive covenants, but it never had anything of uniformity. So the legislature came up with something where we know whether something is still within a development period, and that's when a developer has the right to facilitate the development, construction, and marketing, and also has the right to direct the size, shape, and composition of the subdivision. Now, this has nothing to do with the development control period, but just the period known as a development period. This helps us understand some of the laws. One of the bills that passed that's of great interest to realtors was House Bill 35, which is turned into a section of the Texas Property Code known as 209.015, and this deals with regulation of the land use of adjoining lots. In the past, if it was a single-family community, each lot could only be used for a single-family purpose with a single-family home. In this instance, an adjoining lot can be used for an ancillary purpose, other residential purpose. So you could buy two lots, either facing a street or on a corner, and put the home on one and put other things on the other. The other types of structures that are anticipated by the statute include garages, sidewalks, driveways, parking areas, swinger playscapes, and things of that nature. And if the community allows for storing recreational vehicles, that would also be a permitted use on a second lot. There are some restrictions alongside of this, so that if someone does buy two lots to make the use of the second lot as ancillary, then the lots later must be sold together, or the improvements on the lot without the home must be removed, or the adjoining lot may be used for construction of a new home. So with all that together, an owner can actually purchase two lots and have a little bit bigger homestead and not have problems from a homeowner association regarding having to build a second home on the second lot. And once again, these are for lots that are contiguous, that front the same street, or on a corner lot by the side or back property line. Now, the POA or the Architectural Control Committee has reasonable discretion to put in place regarding restrictions for this, but this law was placed into effect June of 2013, and it is now the law of the land. Other law that got passed, which is another bill dealing with flags. Community associations and flags seem to have had problems on interpretation over the year, and so there's now a definition of what a front yard is. And as long as a home has a setback across the front of 15 feet, then an owner can place the flag inside of the front of the property line, whether it's before or behind the setback line. And once again, so as long as there's 15 feet, then an owner can have a flagpole in their front yard. Now, the laws as to the height and lighting and things like that have not changed, and those are still the same as they were from the previous legislative session. The other thing that happened in this session was some changes to the Uniform Condominium Act. The Uniform Condominium Act can be found within Chapter 82 of the Texas Property Code, and one of the things that was added was a definition of dedicatory instrument. There had been one for single-family homes, had not been one for condominiums. And this is very, very similar to the single-family homes, make it uniform and easier for all of us to understand. Another thing that happened was a little bit of a clarification. Some condominium associations were fining without giving people notices of doing so and without putting together notification of a right to a hearing. This modification to the law also made it necessary for all fining to be done only after notice, only after a right to hearing. The only exception to this being if the owner committed a similar violation with a 12-month period. Inside that 12 months, no secondary notifications would be required. Another change was that the condominium associations now have the right to borrow money and pledge assessments and lien rights. This was a little bit uncertain in the past, and banks were a little bit unclear as to whether they could lend and secure their monies to condominium associations. This has been clarified by laws passed in this last session. Another change to the Condominium Act was insurance issues. And there was no clear law as to whether a homeowner or a condominium owner would have to pay for the deductible portions of the insurance. This is because when the Condominium Act was put into play in 1994, the deductibles on condominiums may have only been $1,000 or $2,000, where now they're 2% or 1% of the value of the entire building. So it's become critical that the deductible portions be covered. And that's something that's dealt with in the new law, which allows for the association to promulgate resolutions so an owner will know their obligations when they purchase their property. Also a little bit clarified that if an owner or a guest cause a damage to the condominium structure or to the common elements, that the costs, including the excess of insurance and deductibles, will be the owner's expense. Another decision that was rendered was by the legislature was that what happens in the case of a common catastrophe? If a building is destroyed, it used to be that 80% of the votes of the owners of the entire condominium, plus all those that were affected, needed to vote to terminate a condominium regime or vote not to rebuild the building, rather. In this instance, now it's just an 80% vote, and all of the owners who are affected do not need to consent for that building to not be rebuilt. And finally, on the condominium setting, condominium associations do have a right to foreclose on owners for not paying assessment. And there was a loophole, if you will, in the law which did not have a right of redemption. This is a right of the owner to repurchase their unit after a foreclosure. Prior to the change in the law, only if the association was the purchaser could this occur. After the law changed, the owner can repurchase their property no matter who the purchaser of the property is. There are a bunch of little technical details regarding how much they need to pay and when it needs to occur, but an owner having a right to redemption is a good thing. There is a change both for condominiums and for single-family communities in what we would refer to as a management certificate. Management certificates have been filed in the property records, which let a potential buyer and a title company know how they can get in touch with the homeowner association or condo association, and as well which documents affect the utilization of the property. These were filed by county clerks in all sorts of locations and not easy to find. The legislature passed new laws which are effective January 1st, 2014, that require they to be filed in a separate category. For example, for condominiums, they're now to be filed in a condominium association management certificate file, and for the POAs, they need to be filed into a property owners association management certificate file, which should make them easier for potential purchasers, sellers, and title companies to locate community associations. Another issue that is hotly contested and seems to change on a biannual basis with the meeting of the legislature is xeriscape laws. Now, community associations have been involved in xeriscape laws for many, many years, but the most comprehensive legislative changes occurred in the past and present legislative sessions. If you have a chance to look at the photographs and handout that's a PDF attached to this presentation, you're welcome to do so. You'll see lots of pictorial examples of things that probably would be accepted by a community association and a few that would not be acceptable to community associations. Now, these laws were effective in September 2011 and 2013, and the most recent changes in 2013 dealing more with drought-resistant landscaping. The things that changed in the past permitted owners to allow for composting, rain barrels, rainwater harvesting, and irrigation systems, all of which would allow for water conservation. The most recent legislative session allowed owners to install drought-resistant landscaping or water-conserving natural turf. And the natural turf was a big deal. There was a lot of fights in the legislature about whether artificial turf would be accepted, and as of today, artificial turf is not acceptable. The issues on composting and on rain barrels are all pretty detail-oriented, but suffice it to say that owners are allowed to have them so long as they're reasonable, they're placed in areas that are not highly visible, and the associations do have rights to restrict locations and appearance of these items. And as for example, with the composting barrels, they're only permitted within a fenced yard or patio, and similar types of restrictions can be placed by associations on the rain barrels, limiting the colors to something that's original, something that maybe blends with the house, no graphics or pictorials on them as well. POA can require, as a part of its organization, the installation of efficient irrigating systems. And as you drive around communities, oftentimes you'll see irrigation watering sidewalks and streets more than lawns, and the goal is to just get as much water onto the lawns that's necessary and not overdo it along the way. Another issue we're dealing to the turf, and this is a problem that I've talked to landscaping folks about, is that the property owner association will not restrict an owner regarding turf and will encourage them to use water conserving turf. But with existing lawns, when an owner comes in and wants to change out their yard, they still need to go through a process of submitting applications because not all landscaping is compatible with each other. And not just from an aesthetic standpoint. If one yard is Bermuda grass and the next door neighbor is a St. Augustine grass, I'm told by the landscape professionals that they will not thrive together, that only one will survive and choke out the other. So this is something that needs to be dealt with by the associations. So if an association has restrictions out there, owners, as they purchase into a community, should be made aware of those. The association also has a right to regulate the installation of gravel, rocks, and cactus, and require you to submit a detailed plan which shows where everything is. Once again, on the PDF attachment, you'll see some submissions of what a detailed submission would look like. The committee can have a right to look at it, a right to review it, but they cannot unreasonably determine that the submission is aesthetically incompatible. And the aesthetic incompatibility is going to be something that the owners and the board of directors of associations will have to work through over the next several years. The submission process itself is something that an association should have resolutions in place for. As well, they should have resolutions in place regarding composting, rain barrels, irrigations, and the like. So before someone buys into a community, they should ask to see the board's resolutions regarding these. These should all be filed of record in the county. All should be available to an owner just by requesting them from the owner. There may be a fee for a copy of them, but it should be a very nominal fee, because in the 81st legislative session, the amount that an association can charge per page is relatively low. So in sum, be sure that when an owner comes into a community, they get copies of all their documents that are necessary for them to make an intelligent decision, and also they should get involved in the process. All of these resolutions are things that the community association has put in place based upon what their present knowledge is, and as they gain knowledge, these rules should evolve. And every owner, including the brand new owner, should be involved in the operation of the association. And be sure to have everybody to have some tolerance, especially with this conversion of xeriscaping, because adjusting is a time-consuming matter. And the intent of the law was to save some water. So along the way, hopefully that's what actually comes out with the xeriscaping. And on a community association front, let's just keep in mind that the community association exists for the benefit of all owners, and they're not there to arrest people, but to enhance and maintain property values. Thank you.